have also read the Constitution and the law. I have distilled 3 questions for determination. Number 1, whether this petition is premature. Number 2, whether the sections impugned are unconstitutional. And 3, whether police officers can be deployed outside Kenya, and Article 248, or generally. Before delving into the main issues, I wish to dispose of a question that was raised by the Attorney General, that the President should not have been joined in these proceedings. The Attorney General, though not representing the President, has argued that the President cannot be sued in the manner he was, and cited the decision of the Supreme Court in the Ndi case. The Attorney General takes the position that the President has a constitutional immunity, and for that reason, civil proceedings cannot be brought against the President while in office. The petitioners argue that the President has been sued in his official capacity and not in a personal capacity, and for that reason, the office is properly sued. Whether the President can be sued or not is an issue that was dealt with in the Ndi case at the High Court and the Court of Appeal, where both courts held that the civil proceedings could be instituted against the President while in office if the President had acted outside the Constitution. On further appeal to the Supreme Court reversed that holding and held that civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during the tenure of office in respect of anything done or not done under the Constitution. The Supreme Court further held that Article 143 sub-Article 2 grants immunity to the President by protecting the President from civil proceedings during his tenure in office for actions or omissions connected with the office and functions of that office. Following the holding by the Supreme Court, it is settled law that the President cannot be sued while in office for anything done or not done while in that office. For that reason, the petitioners could not lawfully include the name of the President in these proceedings, whether in his personal capacity or official capacity. In this respect, the President's name is struck out from these proceedings. Is the petition premature? The respondents argue that the petition is premature and offends the doctrines of ripeness, and they further argue that the petition offends the doctrine of exhaustion. According to the respondents, the petition was filed before Parliament determined the issue of deployment, and for that reason, this court should decline jurisdiction and allow Parliament to consider the issue in exercise of its constitutional mandate under Article 118 and 119 of the Constitution and parliamentary standing orders. The petitioners and the Law Society take the opposite position, that this court has jurisdiction because the issues raised are on the constitutionality of actions complained of, and only the court can determine those issues. The petition was filed on 6th of October 2023 following the statements by the President and CS Interior that Kenya would deploy police officers to Haiti after the UN Security Council passed a resolution on deployment of multinational security service mission to Haiti. The statements from the President and the CS Interior gave the impression that a decision to deploy police officers had already been made. This prompted the petitioners to file this petition to challenge the actions. The petition has filed 6 declarations that the act of deploying police officers to Haiti is unconstitutional, illegal, and void, that police officers cannot be deployed outside Kenya, and sections 107, 108, and 109 of the National Police Service Act are constitutionally invalid, among other reliefs. A reading of the petition and the relief sought that the petitioners seek from this court, it is clear that they seek interpretation of the Constitution and the law to determine whether the position taken by the petitioners is correct or not, whether police officers can be deployed out of Kenya, and whether the impugned sections are unconstitutional are issues that only the court can determine and not Parliament. Even if the respondents argue that a decision to deploy police officers to Haiti had not been made when the petition was filed, that alone cannot make the petition premature or violate the doctrine of ripeness. Regarding exhaustion, the position is that for the court to defer jurisdiction because of the doctrine of exhaustion, the alternative body, in this case Parliament, must be in a position to give an effective remedy to the petitioner's claims. Where the remedy would be inadequate or ineffective, the court cannot defer jurisdiction. In this petition, there is no doubt that Parliament cannot determine whether the impugned sections are unconstitutional. Parliament can also determine whether deployment of police officers outside Kenya is unconstitutional. Parliament's mandate is to approve or decline to approve deployment of police officers to Haiti. It cannot determine the constitutionality of the action. Unlike Parliament, the Constitution has, under Article 165D, 3D, 2, and 2, conferred on the court jurisdiction to check governmental action, and it is the solemn duty of the court to keep the organs of state within the limits of the power and the mandate conferred on them by the Constitution, determine whether any law is inconsistent with or in contravention of the Constitution, and whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution or the law. It is therefore within the mandate of the court to determine the issues raised in the petition in exercise of its jurisdiction. Even if it were possible for the court to defer jurisdiction because Parliament had not made a decision to approve deployment, Parliament would still not determine the rest of the issues in the petition. Furthermore, the issues in the petition cannot be split so that some are dealt with by the court while others are dealt with by Parliament. Where there is an allegation of violation or threat to violate the Constitution, it is within the court's mandate to determine the issue and not any other organ. The petitioners have instituted this petition on the strength of Article 2 on the supremacy of the Constitution and Article 3, which obligates every person to respect, uphold, and defend the Constitution, calling on the court to respond to the issues in the petition in exercise of its jurisdiction in Article 165.3. It is the finding of the court that the petition is not premature, does not offend the doctrine of ripeness, exhaustion, or separation of powers. The petitioners properly approached the court, heeding the call in Article 3.1 on their obligation to defend the Constitution. What about sections 107, 108, and 109? The petitioners challenge constitutionality of those sections in the National Police Service Act. Their case is that the sections fail constitutional test of validity because they allow deployment of police officers outside the country contrary to the Constitution. In advancing their case, the petitioners take the view that the impugned sections violate the purpose and intent of Article 240 of Article 8, which, according to the petitioners, only permits deployment of national forces outside Kenya. The petitioners take the position that the National Police Service functions within Kenya, and therefore police officers cannot be deployed outside the country. In allowing deployment of police officers outside the country, they argue the impugned sections fall the Constitution, and in particular Article 240 sub-Article 8A. The respondents take the opposite view and contend that the sections are constitutional, are not inconsistent with the Constitution. The Law Society partly agrees with the position taken by the respondents that the sections are constitutional and valid. but argues that deployment should only be done as permitted by the impugned sections. To resolve this issue, one must bear in mind the import of Article 2 sub-Article 4 of our Constitution, that any law that is inconsistent with the Constitution is void to the extent of the inconsistency, or any act or omission in contravention of the Constitution is invalid. A law enacted by Parliament must be consistent with the Constitution, short of which it will be declared unconstitutional. Before embarking on the discourse to ascertain the constitutional validity of the or either of the impugned sections, it is important to remind ourselves some of the principles that the court should bear in mind when determining the constitutional validity of a statute or its provision. A statute or provision is presumed constitutional, and it is the burden of the person alleging constitutional invalidity to prove that invalidity. Some decisions are there, you will have to see them. The National Police Service Act was enacted to give effect to Articles 238, 239, 243, 244, and 245 of the Constitution. Article 238 is on national security. That is, protection against internal and external threats to Kenya, its territory, integrity, sovereignty, its people, their rights, freedoms, property, peace, stability, and prosperity, as well as other national interests. Article 239 identifies national security organs, which are the Kenya Defense Forces, National Intelligence Service, and the National Police Service. The primary object of national security organs is to promote and guarantee national security in accordance with Article 238(2). Article 243 established a National Police Service consisting of National Police Service and Administrative Police Service. Article 244 then provides for the objects and function of the National Police Service. These are to strive for the highest standard of professionalism and discipline among its members, prevent corruption, and promote and practice transparency and accountability, comply with continuous standards of human rights and fundamental freedoms, train staff to the highest possible standards of competence and integrity, and respect human rights and fundamental freedoms and dignity, as well as foster and promote relationships with the broader society. Parliament may enact legislation establishing other police services under the supervision of the National Police Service and the command of the Inspector General of Police. That's Article 247. In other words, National Police Service supervises officers of the service, while the Inspector General commands the service. The impugned sections, that's Part 14 of the Act, are on reciprocal arrangements. Section 107 defines a reciprocating country as a country which the President may, on being satisfied that it has a law containing provisions reciprocal to those of Kenya, declare a reciprocal country for purposes of that Act. Notice should, however, be, for such declaration has to be published in the Kenya Gazette. Section 181 authorizes the President, on application by a government of the reciprocating country, to order a number of police officers he may consider necessary to proceed to the reciprocating country for service in that country for purposes of assisting the police service of that country in a temporary emergency. Under subsection 2, a police officer who is punished in the reciprocating country under any of the provisions of our Act, which are applied in the reciprocating country to that police officer while in that country, for an offense that is committed while in that country under the reciprocal arrangement, that officer will be deemed to have been punished in Kenya for a similar offense if committed in Kenya. Section 109, on the other hand, is the opposite of Section 108 and allows the President to apply to a country reciprocating for police officers to come to Kenya under reciprocal arrangement similar to those in Section 108, subsection 1. The petitioner's case is that the impunity sections are constitutionally infirm because they allow deployment of police officers outside Kenya contrary to Article 243, sub-Article 3. I have read that article, which establishes a national police service. Sub-Article 3 states that National Police Service is a national service and is to function throughout Kenya. Subsection 3 does not state the police officers serving within the National Police Service cannot be deployed outside Kenya, but that the service shall function throughout Kenya. My understanding of the import of that article is that National Police Service function in all areas within Kenya to provide security to its people, to its people and their property. As a national police service, National Police Service serves the whole country and not specific areas, counties, or regions that police officers cannot be deployed outside Kenya. The petitioners, having not shown that these articles expressly or by necessary implication prohibit the deployment of police officers outside Kenya, they cannot rely on Article 243, sub-Article 3 to support the argument that police officers cannot be deployed outside Kenya, simply because the service functions throughout Kenya. The language used in Article 243, sub-Article 3 does not support the petitioner's assertion. The petitioners also cite Article 240, sub-Article 8 on their argument that the sections are unconstitutional because they allow deployment of police officers outside the country. In their view, only national forces can be deployed outside Kenya. I have again read Article 240, sub-Article 8, and I found nothing prohibits deployment of police officers outside Kenya. I will, however, say more on this article later in this judgment. Article 243, sub-Article 4 mandated Parliament to enact legislation to give full effect to Article 243. Parliament then enacted National Police Service Act in response to that mandate. Sections 107 to 109 provide for reciprocal arrangement and when and under what circumstances national police officers may be deployed outside Kenya. It is for that reason that the Law Society parts ways with the petitioners on deployment of police officers outside Kenya. The Law Society takes the position that the impunity sections are constitutional since they provide a mechanism under which reciprocal arrangement be undertaken. That is, any reciprocal arrangement must comply with the procedure in Article 107, 108, and 109 for deployment out of the country or into the country. For instance, a notice must be published in the Kenya Gazette on the reciprocating countries for purposes of accountability. Article 2, sub-Article 4 of the Constitution is unequivocal that a law will be void if it is inconsistent with the Constitution. Where a provision is said to be inconsistent with the Constitution, the inconsistency must be plain and clear when the provision is laid against the article of the Constitution it is said to be inconsistent with. Have I gone through the various articles of the Constitution the sections are said to be inconsistent with? I have not been able to find any inconsistency between the impunity sections and those articles. Where it is alleged that a statutory provision is inconsistent with the Constitution, the court embarks on a fact-finding by laying those sections against the articles of the Constitution said to be offended and determines the infirmity, if any. Invalidity may be on the purpose for which the statutory provision was enacted or the effect of its implementation. If the court finds infirmity or inconsistent in the challenged sections, it has no option but to declare those sections invalid as decreed by Article 2, Sub-Article 4. The petitioners have not demonstrated any invalidity in the impugned sections. In any case, the import of the impugned sections is to allow mutual reciprocity between Kenya and other countries. Section 109, for instance, mandates the President to request a reciprocate country to send police officers to Kenya where circumstances similar to those under Section 108 exist. The benefit would be to both reciprocate countries, and for that reason, I see no inconsistency. Deployment of police officers. The main gist in this petition is whether police officers can be deployed outside the country under Article 240, Sub-Article 8 of the Constitution. The petitioners and the Law Society argue that because National Police Service functions within Kenya, its officers cannot be deployed outside Kenya under Article 240, Sub-Article 8. Their position is that only national forces can be deployed outside Kenya and not National Police Service because it is not a force. The petitioners and Law Society assert that Article 240 only allows the Council, with approval of Parliament, to deploy national forces outside Kenya for regional or international peace or other support operations. The national forces referred to in Article 240, Sub-Article 8, they argue, does not include National Police Service. The respondents maintain that a holistic reading and interpretation require that Article 240, Sub-Article 8 be read alongside Article 239 of the Constitution. In their view, national forces referred to in Article 240, Sub-Article 8 refers to the Kenya Defense Forces, National Intelligence Service, and National Police Service collectively. The respondent asserts, therefore, that the Council has power to deploy any of the three security organs out to the country under the circumstances contemplated in Article 40, Sub-Article 8A. The decision on this issue turns on the interpretation of Article 240, Sub-Article 8. In determining this issue, the Court must be aware of its obligation under Article 159, Sub-Article 2E, when exercising its judicial authority, including that of interpreting the Constitution, to ever have present in mind the obligation to protect and promote the purposes and the principles of the Constitution. Similarly, Article 259 calls on the Court to adopt an interpretive approach that promotes the purpose, values, principles of the Constitution, advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. The Constitution should also be holistically and purposefully interpreted in a manner that advances its purposes, gives effect to its intent, and illuminates its contents. There are decisions there I've referred to, which you will also see. In some decision from India, one judge who was writing for that Supreme Court cautioned those on whom the duty to interpret a constitution falls, and this is what he said. We can always find some reason for bending the language of the Constitution to our will if we want. But that would be rewriting the Constitution in the guise of interpretation. We must also remember that the Constitution is an organic instrument intended to endure, and its provisions must be interpreted having regard to the Constitutional objectives and the goals, and not in the light of how a particular government may be acting at a given point of time. Judicial response to constitutional interpretation must not suffer from the fault of an emotionalism or sentimentalism. which is likely to cloud the vision when judges are confronted with issues of monumental importance. End of quote. This court will therefore proceed on the basis of the above principles, determine the objectives and the goals of Article 240, Sub-Article 8, and give true meaning